You're sitting in a meeting at your child's school. There are 4, 5, 6 people on the other side of the table, and they're explaining calmly, professionally, why your child can't receive the services you requested. And you know they're wrong. You have the reports, you have the documentation, but the words aren't coming out right, or they're just like talking over you. Or you could feel yourself starting to cry, and you definitely don't want to be crying in front of them. And then you leave with nothing changed. And then you sit in your car and you think, damn, I failed my child. You did not fail your child. You just did not have the right tools. And this video is one of those tools. By the time it ends, you'll have the specific language, a clear framework, and the legal knowledge to walk back into that school and advocate in a way the system is required to respond to you. Not because you got louder, but because you got smarter about how the system works. I'm Nurse Zee, registered nurse with 20 years plus experience as an emergency room and pediatric nurse, currently working as a bilingual case manager for an insurance company. And I'm also the mother of a special needs daughter that's 23 years old, that is blind with developmental delays and is autistic. I know how institutions talk to families, and I also know what they're counting on families not knowing. I have been in those meetings on both sides of the table. On the side where the folders have the system, a script, and a legal framework that they know very well. The side with the parent, and they're usually winging it. But today we fix that. Your child's rights are governed by IDEA, which stands for the Individuals with Disabilities Education Act. Under this act, your child has the right to FAPE, FAPE, which stands for a free, appropriate public education designed to meet your child's unique needs. Not perfect, but appropriate. So here's what school counts on you not knowing. You are a required member of that IEP team. You're not a guest, not a stakeholder, but a required member with equal legal rights standing at that table. They cannot finalize that IEP without your participation. And you have the right to disagree, put it in writing with any part of it. So when the school says no to anything, just say this: I am requesting prior written notice of this decision in writing. That will create the paper trail. And with the paper trails, that's how appeals are won. So 5 strategies, write these down. 1, email the day before every meeting. Confirm the topic, say you're just taking notes, and this creates a record, signals that you're organized, and it puts the school on notice that you are documented. Number 2, when you disagree, don't argue, just ask. The most powerful phrase: can you help me understand how that decision is based on my child's specific data? Not general data, my child's specific data. If they can't answer, write it down. Number 3, within 24 hours of every meeting, send a follow-up email summarizing what was discussed in the meeting. So you're going to put my understanding, what we agreed in this meeting, blah, blah, blah. If I have misunderstood, please let me know within 5 days. That email becomes the official record and you become the witness. Number 4, you're allowed to bring somebody to the IEP meeting with you. It could be a friend, a family, a parent advocate. So under this IDEA Act, anyone with knowledge or expertise about your child. A second set of ears can change that dynamic quickly. Number 5, if you disagree with the IEP, write on that document before signing it, specifically write, I am signing to indicate my attendance, not my agreement. Or attach a letter of disagreement. You don't have to agree to participate. Your disagreement is going to be part of that record. And when nothing else works, you request a meeting with the special education director, not just the coordinator. You contact your state's parent training and information center, PTI, which is free, it's federally funded. You're going to file a state complaint with your state's Department of Education. They have 60 days to investigate. You're going to request mediation, which will be a neutral third party and free to you. Because when they know that you know the escalation path, things move real quick.